welcome again to Divergent Motivation channel. Hope you enjoyed the last video. This one is again for the newbies. And let's see if we can add a little bit more value. So we were the last video in the home page of the website, and I think that it was a good place to start. And today, well, I'm hoping, of course, that you guys were able to navigate in the ins and outs of the website, which is very easy. And did you were able to download the affidavit as well? What happened here? Okay, so here we have it. Yeah, so downloading the affidavit, so you should be able to download it here. And today we are going to read and try to see if you guys really grasp the whole idea of the affidavit. Okay, so in this section here, you have the reading of the affidavit. If you don't have like that, if you don't feel so comfortable reading the affidavit, so you can listen here. Yeah. Well, it's not working. Why it's not working? Maybe it's because I don't have the program installed yet. Probably it might be just it. Okay, let me see if we can find it here. Should be. Yeah, okay, so you have the, again here, the for you to have to listen the reading of the affidavit. Yeah, here is the original Baron David Ward's affidavit. You have from Australia, you have from Portugal, you have from India. There is a few here missing. We already have in Spain, and somewhere else there is, well, we have Portugal, Spain, India, Australia. Can't remember if there is any more, but yeah, okay. So here is the first page that you will see. So today we are going to touch and try to break down what is what. I hope you guys are seeing it. Yeah, so this is the page that you will see. Yeah, there's two pages. Yeah, so the first one is the decree. Let me go back to it. Where is it? Here. Oh no, why is it going forward? I don't want you to go forward. I want you to go backwards. Let's go backwards. Yeah, okay, here it is. So when you first start reading, there are a couple of things that you need to pay attention. Yeah, or not when you first read it, when you go back to it, let's just say that. Yeah, there are a few things trying to break it down for you now. So what you need to really understand is this page is the decree. Okay, so you have the 2-page decree. You have here in brackets the postal code. And there is a reason for the brackets be there. I will explain this when I'm explaining some other stuff. This here, it's the accreditations of Baron David Ward. So if you are creating yours, this one, you just remove his accreditations and you just leave the attorney at law, no assured value, no liability, no errors in omission accepted, all rights reserved. Okay, so decree, this is our decree. Then this is where the affidavit starts. Okay, so I, Baron of the House of Ward, being the undersigned, do solemnly swear, declare, and depose that I am competent, and you can read it, yada yada yada. So here it's where the affidavit starts. So the two first pages are a decree, and this is the affidavit, which is 2 pages as well. When we finish this, we go to the exhibits inside of the affidavit, which is the ones that are going to support our affidavit. And we say they are going to support because you have this point here, and it starts from Exhibit A, the formal challenge of the 12 presumptions of law. A presumption is something that is presumed to be true. And as a presumption, there is only a need for a formal challenge to the presumption is dismissed that the presumption until the physical and material evidence can be presented to support the presumption. Okay, so this is the point that you are making in your affidavit, and then you back them up with the facts. Okay, so this is the here you have Exhibit A, which is the formal challenge to the 12 presumptions of law. And here you have the definition of presumption. You have also the definition of probability, and then you have the Boolean grammar, which is then an equally, okay, which is very critical that you understand how to write your future communications with Boolean grammar. There is one of the videos of Baron David Ward where he explains why it's so critical to have that in there. Then it goes on to see what is the presumption. So you have the presumption of public records. And what is going to happen is that there is the presumption of public records, right? And then you go, we, the undersigned, formally challenge the presumption of public records, as it is by definition a presumption. A presumption by definition has no standing or merit in presentable or material fact. And we go and rebut all the 12 presumptions. Then you have the presumption of public service. You have the presumption of public oath, presumption of immunity, the presumption of summons. You have the presumption of custody. You have the presumption of court of guardians. You have the presumption of court of trustees. And you have the presumption of government acting into roles, the executor and beneficiary. You have the presumption of agent and agency, and the presumption of incompetence, and the presumption of guilt. Okay, so what we say is we formally challenge all presumptions of law, and we have formally challenged all the 12 presumptions of law then the presumption of law formally has no substance in material fact. Guys, this is so important that you understand that you are formally challenging the 12 presumptions of law. Okay, that's why you have we the undersigned formally challenge the presumption and yada yada yada. Okay, then you have as a scholar of law and recognize RBA, recognized by achievement. So this section here, if you are creating your own, you have to remove this area here where it starts as a scholar of law and recognized RBA, recognized by achievement, paralegal by the demonstration knowledge at a court tribunal. See the case authority exhibit B. If you have this recognition, so you leave and you add it to the recognition that you have. In that case, if you don't have any, you just remove that. And you can leave, so you can leave this we formally challenge all presumptions until the material facts. You remove all this and you will leave this part here. We will recognize the rule of law when and only when there is the material evidence of that assumed. God, this is so that assumed rule of law has some material evidence or of substance in presentable material fact. Until that, the search for the rule of law that has some credibility in material fact continues. It's done without ill or vexation. Yada yada yada, yada 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 yada. I want to see if oh no, I wanted to see if this can go a little bit. If I can zoom it, but it's not. I don't know, maybe it's the format where it is, but it's not allowing me to zoom. Perhaps if I go here, oh, much better. Oh yes, much better. Maybe because it was in that. Yeah, much better. I was doing some effort to read the tiny letters that was, I couldn't see it, but okie dokie. Okay, so now we go into Exhibit B, which is the Baron David Ward's case with Warrington Borough Council. This case was on the 30th day of May 2013. As by now, I hope you already listened to him explaining that he only did this, so he only gathered this affidavit in 2015. And he put this case in there because this case was the beginning of everything, and we will see in a while why that was the case. So here we have the case overview. Yeah. So what the government would like people to believe is that the procedural impropriety is an acceptable mistake which can be overlooked. But what this is a deliberate act of fraud and also malfeasance in the public office. Okay. So one of the things that I normally say, and I speak this because I had this, barrage, because English, of course, is not my main language. So there were words that I didn't quite understand what was the meaning of those words because I wasn't used to them. And we've been seeing also that there is a lot of people that have, this is not your type of language, you know, it's not something that we say malfeasance or misfeasance or whatever that is, right? So what I normally say to people is take your time reading the affidavit, and what you can do is you can come here to this words and you just like leave a notice in there, or if you print it yours, just as you go and read and you don't understand, you just cross this word, and you just do a research on the words, you know. Or if you are online, you can come here to Google and you go here and you put the word malfeasance and you can write the meaning. Okay, and here we go. So you have some here, and it says malfeasance is an act that is illegal and causes physical or monetary harm to someone else. Malfeasance is intentional conduct that is wrongful or unlawful, especially by officials of public or public employees. Okay, so you can you have some of the words here. You have also misfeasance. The police, government, and other state agencies should only have used their powers for the public good. And though the sentence for misfeasance in public office will depend on the harm caused and the level of responsibility exercised, the maximum penalty is life imprisonment. Okay, so this is why it's very important for us to understand what these words mean, what is the meaning behind the words, and why did Baron David Wood use this in his documents, right? So another thing that I like to do is go through the etymology of the words. Yeah, so you have here a brief description, and you can also go to etymology online, and you can read what it says in there. Okay, so malfeasance, wrongful conduct, the doing of which ought to not to be done, especially official misconduct, violation of a public trust or obligation. In the 1690s, from French malfeasance, wrongdoing, from malfaçon, je ne sais pas, from mal, badly, see mal. It's funny because mal is Portuguese words and is mal, exactly as it is written, and is wrong. It's the meaning of the word. So present principle of fair to do, from Latin facere, to do. Exactly. It's Latin for us is very I mean, for the Portuguese, it's very easy because most of our language, it's provenient from Latin. So facere, we say fazer, and it means to do. So yeah, it's very easy for us to like grasp, because that's why also we have lots of words, you know, so basically that too. Or to see put. Okay, so this is one of the ways that you guys can go and have a better understanding of the words contained in the document. So this is one of the ways that you can do that. And okay, so moving forward, again, that's why he says here there are these are very serious crimes with criminal intent. So fraud is a deliberate action to defraud where the victim of the crime is unaware, having no knowledge of the situation or fact. This crime carries a penalty of 7 to 10 years incarceration and the later where there is multiple instance of. So the 63.7 million people are subject to this crime every day, and is now commonplace, and it is carried out by the largest and most ruthless criminal company in this country. Then we have here the, again, malfeasance, misfeasance, and nonfeasance. I highly suggest you guys to go to the etymology of the words and discover why he put these words here and what is the meaning behind the words, okay? Then we go to see that Baron David Ward starts to explain. So this case, which was undertaken at the tribunal and therefore recognized due process, confirms to be the facts of the matter. So the case details. This may be a simple PCN, penalty charge notice, but close observation of the details will conclusively show otherwise. This is the PCN issued by Warrington Borough Council, which clearly shows that a claim is being made under the Traffic Management Act of 2004. And there is clearly no disclosure to the fact that there is no liability to pay or to play as well, either way, as the outcome will show. Okay, so it's interesting because this you will hear Baron David Ward, that the guy scribble the PCN, and at that point he got super excited because before that, previous to that, he was shouting and like a madman at the guy, but as soon as he saw that the enforcement office sign or scribble the piece of paper, he just went like, whoa, I got you now. So here we have some of the things that Baron David Ward lined down, which is, if you believe, and guys, I love to read this because now that you know, it's so important that you go to this detail, you know, go into, when you are not just reading, you know, just focus on everything, every piece counts, every little detail counts, okay? So it says the following: if you believe, it's a belief, my friends, that the penalty should not be paid, and you wish, oh my God, we have a belief and a wish in one single sentence, and you wish to challenge this PCN, okay, write to Warrington Borough Council, you know, yeah, just write to the walls if you want. Inquiries and Payment Office, level 6, yada, 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 yada. Or email at yada, 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 yada. Or you can call as well, you know. I mean, it's whatever you wish, basically, okay? So, this is also very interesting. Please be aware that payment closes the case. Oh my God, there is a case. Payment instructions are printed on the reverse of this notice. Is it the wish and the belief? Oh, we have the instructions for payment. Of course it is. You can pay by post, you can pay by telephone, you can go to the online, yeah, or you can do it in person, you know. Yeah, that's it, you know, whatever is good for you, yeah. So the next document and physical evidence is the notice to owner from the same Warrington Borough Council, which also quite clearly makes the claim that there has been a violation of the Traffic Management Act of 2004, Section 82, on the 8th of April of 2013. Okay, so guys, pay attention to the dates, yeah? So here we have all the details. You guys are familiar with this, yeah? You, the owner, whatever you is, keeper or hire, are liable, one, two, or as many are all liable for the penalty, charge, and notice. Do not ignore this notice or pass it to the driver as you wish. Again, you know, it's up to you. All we want is the money, the faith and belief, along with the opportunity to make presentation to why there is no liability. Okay, why am I focusing on this particular exhibit? Because here it's where everything is, and you need to know this one, because this specific exhibit, it's like the juicy of the juice, yeah? Many people look at this and say, oh yeah, but this was just like PCN, you know, nothing major. But if you pay attention, and if you read every single thing, you will see that it's not the case. You know, your mind is telling you something because it comes from a position of believing, you know, but it's completely different. And when you get to Exhibit C, you will clearly have a better understanding of why this is put out this way. Okay, so let's move on. Okay, so in this section, we have here. So again, Section 1, grounds for representations. Please tick the grounds on which you are making representation. I am not liable to pay the penalty charge because, and there is a tick there, the alleged contravention did not occur. And it shows there has been a procedural impropriety by the enforcement authority, and the order which is alleged to have been contravened in relation to the vehicle concern is invalid. He already knew what was coming, so it's funny. Okay, so we would also point out at this point that this is an unsigned notice and not a legal document. The mitigating circumstances is that there has been a procedural impropriety, which is clearly an option, as this is clearly stated on the notice to owner. So it is apparent that there is a procedural impropriety in place, and this is known by Warrant and Borough Council. Otherwise, this option would not be a part of the notice to owner. We also took the opportunity to utilize a second option which confirms there is a procedural impropriety and that the order which is alleged to have been contravened in relation to the vehicle is invalid. Why else would these possibilities be on this notice to owner if there was not a procedural impropriety? We also took the opportunity to complete Section 3 of the notice to owner to clarify the procedural impropriety on a separate piece of paper as advocated by Warrant and Borough Council, as there was not enough space on the notice to owner provided. These presentations were as follows. So if you can see here, there was not enough space to say anything, you know, just they put this and they expect, oh yeah, you won't notice, or yada yada, there is nothing here. So what Baron David Ward did was this here. Okay, so on the 16th day of April of 2013. So notice of opportunity to withdraw, and notice to agent is notice to principal, and notice to principal is notice to agent applies. So do not ignore this letter. Ignoring this letter will have legal consequences. Here he goes on and say, dear sirs, as you can see here is Warrington Borough Council. We don't know who we are speaking with, right? We do not know who to name as the recipient of this communication, as the sender failed in his or her duty of care and did not sign the document sent to Mr. David Ward at his address. The action of not signing the document sent to Mr. David Ward legally means that no living person has taken legal responsibility for the content of the document on behalf of Warrington Borough Council. And the document cannot be legally responded. Guys, notice that I'm doing like this legally, yeah, this emphasis on the legal side of it. Because it's also important to know what legal means. So that very act of not signing the document renders the document void and therefore non-legal and unusable in law under the current legislation. So strike one, deliberate deception. This document will now be kept on file as a physical presentable evidence as it represents the criminal activities of the representatives of Warrington Borough Council, whether they are aware of this transgression or not. Ignorance of the law is no defense. That's what they keep saying to us, right? And all of the representatives of the Warrington Borough Council are now culpable under the current legislation because one individual failed to sign the document. This is a fact which must be understood. And by that fact, it's strike two, ignorance of current legislation. So the second big mistake on the document is that the document is a notice to owner. Under current legislation, the owner of any motorized vehicle is the DVLA. This means that some imbecile at Warrington Borough Council has sent a notice to owner to the register keeper and not the official owner. So again, strike three, document sent to the wrong address. We have not progressed beyond the first line yet, and we are falling around on the floor in a state of hysteria at the competence levels demonstrated by the representatives of Warrington Borough Council. Mr. David Ward is the official register keeper, not the owner. It's just brilliant. I love this, to read this, and you guys should also take your time to really grasp what is playing at here, because it's just like, wow, you know. So the very next line refers to the Traffic Management Act of 2004. Now this is where things get really interesting, because the act referred to is an act of HM Parliament and Government PLC, a recognized corporation or an all-for-profit business, an act which is not law in the UK. It is not even referred to as law, as it is an act of a corporation or an all-for-profit business or policy, but it is not law. So again, we move to strike four. Displays lack of understanding and competence regarding what is the difference between law and legislation. Acts and statutes of HM Parliament and Government PLC can only be given the force of law by the consent of the governed, which have agreed to those acts and statutes of HM Parliament and Government PLC. Therefore, there is a mandatory legal requirement under current legislation that the government must have given their consent legally, again legally, which can be physically presented as fact before the acts and statutes of Agent Parliament and Government PLC can be given the force of law, not enforceable. 63.5 million people in the UK have not legally entered into those agreements in full knowledge and understanding of their own free will, which must be kept on public record for the acts and statutes of Agent Parliament and Government PLC to be given an action which involves force or force of law. The answers to the questions are in the understanding of the words used to implement acts of force or law. So the next item we come to is a demand for payment. A demand for payment without a signed bill is a direct contravention of the Bills of Exchange Act 1882. So again, we have strike 5. The Bills of Exchange Act 1882 is based upon a pre-existing commercial contract or agreement. See Bills of Exchange Act of 1882. Profiteering through deception is an act of fraud. Again, strike 6. See Fraud Act of 2006. Insisting on demanding payment without a pre-existing commercial agreement, which is based on presumptible fact, is the form of a commercial agreement, is an act of deception. Payment is a commercial activity. You have been served legal notice. Mr. David Ward has no recognizable legal means to respond to a demand for payment without a signed bill which is based upon a pre-existing commercial contract or arrangement or agreement, because there is no standing commercial contract or arrangement or agreement between Mr. David Ward and Warrington Borough Council. If Mr. David Ward was to willingly comply with the demand for payment without a commercial recognized bill, then Mr. David Ward would have knowingly given consent and conspired to a commercial fraudulent action. This, in turn, would make Mr. David Ward culpable under current regulation for that action. Mr. David Ward will not knowingly create that liability against himself or create that culpability. This is what we need to understand, that after we come in contact with the facts, there is no way you will be entering into any of these fraudulent actions. That's why we say that your life changes, and you cannot go on and continue to pretend that all of this is it is what it is, because it isn't, because now you have the knowledge and you have the facts to support that knowledge, and your actions and your attitude towards things will change, unless of course you are presented with the affidavit but you still continue to live in fear, and you still continue to think that others need to do stuff for you because you don't feel like confident enough, or you don't feel like you can do. But again, that's you telling a lie to yourself, because each one of us were able to stand our ground with the facts, and the facts are the same for you, me, and everyone that comes in contact with this document, okay? So the very presentation of the document that we are responding to from Warrington Borough Council, which is also a document that will be kept on file for future presentation as physical evidence, which is presentable physical evidence that and a list of transgressions against the currently held legislation. This same document supplied by Warrington Borough Council recognized that there may be or has been a procedural impropriety by the enforcement authority. This is the only saving grace on this document, which allows for a honorable withdrawal of the proceedings implemented illegally by the enforcement authority. So that was just amazing, just that piece over there. Okay, so this document is representation as to the procedural impropriety by the enforcement authority, and as stated at the outset of the document, gives an opportunity to withdraw due to the procedural impropriety by the enforcement authority. This process is also a matter of complying with current legislation, without which Mr. David Ward would be unsuccessful if he were to pursue legal proceedings against the enforcement authority and or the members of Warrington Borough Council. As the opportunity to withdraw has now been presented to the enforcement authority and the members of Warrington Borough Council under a procedural impropriety by the enforcement authority, should the above mention not take the opportunity to make an honourable withdrawal and confirm such in writing to Mr. David Ward, then Mr. David Ward will be left with no other option in the future but to start legal proceedings against the enforcement authority and the members of Warrington Borough Council. So the content of this document will be in the public domain in the next few days, as there is no agreement in place which is legally binding with which to prevent this. We don't expect to be hearing from the enforcement authority and or the members of the council again, unless it is in the form of a written confirmation of withdrawal of proceedings. No further correspondence will be entered into regarding this matter. Without prejudice, all natural and unalienable rights reserved for and on behalf of David Ward. So, Mr. David Ward reserves the right to use force to defend himself, his family, and his family home, which he has an unalienable right to do so. Response to this notice should be forwarded within 10 days of receipt of this notice to the postal address known as yada 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 yada. No assured value, no liability, no errors and omissions accepted. All rights reserved without recourse, non-assumption. You have been served legal notice. So at this point, the council decided not to recognize the representation given or the requirement for Warrington Borough Council to present the legal and presentable consent of the government. Very key word here, consent of the governed, which is mandatory for Warrington Borough Council to have the correct legal authority before acting under the Acts and Statutes of Parliament. It is also important to note that Warrington Borough Council did not at this point contest the presentations made. So here we have, this is very amusing, okay? So we have David Boyer, which is the assistant director, the interim chief executive, Professor Stephen, I don't know, can't read that name, Broomhead? Is it Broomhead? Yeah, the Broomhead, yeah, okay, it suits them, yeah. If you have difficulty making contact, well, Mr. Broomhead, I surely do. Okay, so here we have it on the 23rd of April of 2013. This is what Baron David Ward got. So, dear Mr. Ward, notice of rejection of representations. Okay, so it's a notice, guys. It's just a notice. Traffic Management Act, Section 78, yada yada yada, yada yada yada. Okay, and it says the following: your representations against The above penalty charge notice have been carefully considered in the light of the circumstances at the time and in accordance with the Traffic Management Act of 2004. Grounds for cancellation of the charge have not been established, and this letter is the formal notice of rejection of representations. Oh my God. Okay. So the reasons for rejection are, and Baron David Ward put, of what? What the hell are you rejecting? Guys, can you understand why he's making this question, right? Of what is going on? Your vehicle was parked in a designated disabled person's parking place without displaying a valid disabled person's badge in the prescribed manner. Unfortunately, oh my God, yes, you cannot park in a disabled bay unless you are clearly displaying a valid disabled blue badge. The traffic information sign and yada 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 clearly states disabled badge holders only. Really? Oh, fantastic. How about that, huh, guys? So we go, and Baron David Ward goes on to say, there is no effective contest to the presentations made. So the presentations made stand as fact. Okay, so that one that we were reading before. Also, at this point, Warrington Borough Council invited Mr. David Ward to take Warrington Borough Council to tribunal, and the outcome would be legal and binding on both parties. So we took the advantage of this generous offer, and we also included a copy of all documents up to this point as physical evidence. This was the same process as before, along with same presentation sent to Warrington Borough Council, along with a letter to the adjudicator as follows. I love this letter, guys. I just really love this letter. So, dear adjudicator, please forgive the informality as we have not been made aware of the name of the adjudicator. This is in response to yada yada council decision to reject our challenge against the PCN. Clearly, the PCN has been challenged by Mr. David Wood, but that challenge has not been rebutted by Warrington Borough Council as Warrington, I'm just going to abbreviate this, WBC, have only repeated the grounds under which the PCN was raised. Copy under the same cover, which is highlighted. Also, a PCN is a penalty charge notice, and as such, a notice of a penalty charge. A recognizable bill has not been raised and presented to Mr. David Ward, complete with a wet ink signature. As the presentations made by Mr. David Ward were not addressed, then the challenge made by Mr. David Ward will still stand, and the PCN is not valid or enforceable. So WBC has made a demand for payment, but it has not presented Mr. David Ward with a bill which is recognized under the bills of exchange, which also must have a signature in wet ink. WBC cannot raise a bill because there is no commercial arrangement in place between WBC and Mr. Ward under which to raise a bill. For Mr. Ward to respond by paying without a bill signed in wet ink, then that would be a direct violation of the Bills of Exchange Act of 1882. In addition to this, as there is no commercial arrangement and a bill presented, then this would also be a contravention of the Fraud Act of 2006. Mr. Ward is not in the habit of knowingly conspiring to fraud. This action would also create a liability against Mr. Ward. WBC has also listed in their rejection of presentations the Traffic Management Act of 2004, Section 78, in support of their claim. The acts and statutes of HM Parliament and Government PLC can only be given the force of law by the consent of the governed. It is mandatory in the first instance is the consent of the governed, which is also presentable as fact. As the consent of the governed is not presentable as fact, then the acts and statutes of HM Parliament and Government PLC cannot be acted upon and in any way which would cause loss to the governed. What is mandatory in this instance is the presentable agreement of the 63.5 million governed to be in place before an act or a statute can be acted upon. We failed to see how this is in support of the PCN presented to Mr. David Ward. We failed to see how listing the Traffic Management Act of 2004, Section 78, supports the claims made by Warrington Borough and Council in any way other than create obfuscation in attempt to confuse the mind. So again, here, what he did is very cleverly, he went to the foundation of why this acts and this legislation needs the consent of the governed so they can be acted upon. And without that consent, they cannot be enforced or whatever, so there is no liability under that. There are no agreements in place between the 22 million residents of the Warrington Borough and Council, and which can be presented as fact, complete with signatures in wet ink, which can be presented to support the claim of Warrington Borough and Council. This is a big name to say. Blah. In support of a demand for payment without violating the Bills of Exchange Act of 1882 and the Fraud Act of 2006, Section 2, fraud by false representation. So you can go and see the legislation there. And Section 4, Part 2, a person may be regarded as having abused his position even though his conduct consists of an omission rather than an act. See legislation, yada yada. An omission in the form of an omitted signature would constitute an act or fraud under Section 4, Section 2, or the Fraud Act 2006. So let's summarize regarding the grounds for appeal with reference to the form provided for appeal. So here we have all these things. And he goes on to say, need we continue? It is obvious at this point that there is nobody, the body, at WBC that is capable of understanding that the challenge made by Mr. Ward or capable of responding. Therefore, an adjudicator becomes necessary. There is only one outcome to this tribunal, where the adjudicator is recognized lawyer and is independent of the council. So again, you can read all this, which is also good. There can only be one outcome to this tribunal, which is acceptable under current legislation, and that outcome will be found in favor of the appellant, Mr. David Ward, and not in favor of continued transgressions against current legislation by WBC. In the document provided outlining procedure to make presentations in this tribunal process, there is a section concerning costs in favor of the appellant, where a party has behaved wholly unreasonable. We have taken a considerable amount of time and energy responding to WBC when making representation and in preparation for this tribunal. It is not without reason that a consideration could be expected. This would also serve to enforce the decision made by the adjudicator in this tribunal. If the adjudicator is truly an independent and honorable individual, then a consideration is in order. Mr. David Ward also notes that as this tribunal is informal, then it is also recognized as not legally binding regardless of the findings of the adjudicator. We would also like a response in writing from the adjudicator to relay the outcome of this tribunal, conveying the reasons for the adjudicator decision. So for and on behalf of Mr. Ward, yada yada. Again, there are addition charges in international law that the adjudicator may not be aware of at this time. Please consider the following, which also has some bearing on this tribunal. Here on the 30th of May of 2003, we got the results from the tribunal as follows. The decision cover letter, yeah. And we have David Ward versus Warrington Borough Council. Enclosed, you will find the adjudicator's decision. A copy has been sent to the council. The adjudicator's decision is final and binding on both you and the council. The attached notes explain the consequences of the decision, but must be read subject to any specific directions given by the adjudicator. If payment is required, please send payment to the council, not to the Traffic Penalty Tribunal. Yours sincerely, Carrie Conway. So clearly this is a tribunal, and as such recognized due process, which is legal and binding on both parties. In addition to this, there was the adjudicator's decision, which you can find it here, adjudicator's decision. And here we have it. Appeal allowed on the ground that the council does not contest the appeal. And the reasons. So the PCN was issued on the 5th of March 2013, yada yada, to the vehicle, yada yada, for being parked in a designated disabled person's parking place without clearly displaying a valid disabled person's badge. The council has decided not to contest this appeal, okay? So the council, yeah, has decided not to contest this appeal. The adjudicator has therefore directed that the appeal is allowed without consideration of any evidence or the merits of the case. Wow, both of them, huh? How beautiful they are. The appellant is not liable to pay the outstanding penalty charge. Wow, brilliant. So the proper officer on behalf of the adjudicator, yada, yada, yada. And here we have appeal allowed on the ground that the council does not contest the appeal. The council has decided not to contest this appeal. Well, WB Council cannot contest the appeal. There is a mandatory requirement for WBC to present a physical evidence and factual foundation for the claim, which is the legally signed on and for the public record consent of the governed. This is the legal authority that WBC would have to present as physical evidence and foundation for their claim, for the claim to have any legal substance in presentable fact. He who makes a claim must also provide the foundation and the physical proof of that claim. Otherwise, the moon could be made from cream cheese just because WBC claimed this is so. So without this physical evidence, then the claim is fraudulent, hence a crime is committed by WBC, and that crime is fraud, not a procedural impropriety or a mistake. Also, there is a second crime. The second crime is malfeasance in the public office, a clear and intended action to extort funds where there is no legal authority to do so. So we have the adjudicator has therefore directed that the appeal is allowed without consideration of any evidence of the merits of the case. Clearly, there are merits of the case which have been presented here. The appellant is not liable to pay case number dated on the 3rd day of May. There is also confirmation of this fact from WBC and signed in wet ink by an officer of the state, which is the amazing Scott Clark, dated the 29th day of May of 2013. And here we can clearly see, well, not pretty much, but the original is a real signature, and yes, the name and everything. Yeah, so here we have it, a no contest with all the evidence that was presented. But they decided, of course, they would not say, yeah, you won and we lost, and you guys yeah, are in the right and we are in the wrong. That would never happened. Okay, so due to the anticipated shortage of parking service staff, Warrington Borough Council has no alternative except to exercise our discretion and cancel the above penalty charge notice. So this is a very interesting choice of words, which is obfuscatory in nature. Warrington Borough Council will never be able to provide staff which can provide the legal consent of the governed, because for the past 800 years, the governed have never once been so much asked to provide the legal consent of the governed on and for the public record. And WBC or its parking service staff cannot provide something that does not exist and is of no physical substance for the foundation to the claim. Okay, so I highly recommend you guys to continue to study this Exhibit B. Take your time going through it and really grasp what is going on in there. And I will wrap this one out for now. And we will see each other in the next episodes of Affidavit and Liens for the newbies. If there is any questions you guys would like to ask or anything that you would like to propose for our next newbie videos, just let me know in the comments below and I will get to them as soon as possible. Until then, good readings guys, and we will see you in the next episode. Bye bye for now.